All right, guys, come on in, have a seat. We got to get into this new court update. In the matter of Megan Pete versus Milagro Elizabeth Cooper, I have obtained the transcripts of the pretrial conference. Let's get into it.
I said, Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah.
All right, y'all. Before we actually get started, I want to make sure y'all see my copyright disclaimer scrolling at the bottom of your screen, simply saying that, hey, this is fair use. I am not a paralegal. I am not an attorney, and I'm also not a judge. I'm simply saying that, hey, I have common sense and I know how to read. Also, top left-hand corner of your screen, direct link to my X, formerly known as Twitter page. And without further ado, here is the transcripts, guys. Okay. October the 30th, 2025. This went from 9:45 a.m. to 1:41 p.m. Okay. It is a total of 94 pages. Okay. Disclaimer. Bear with me. There might be a few words that I may get wrong, but hey, it is what it is. Okay. We're going to keep trucking on, trucking on. All right. Let's start on page 3. Okay. Call to the order of the court. The court, good morning. In the case of Megan Pete versus Milagro Cooper, counsel for plaintiff, please state your appearances. Mr. O'Sullivan. For the plaintiff, Your Honor, John O'Sullivan from Quinn Emanuel. The court, nice to see you, Mr. O'Sullivan. Miss Manillo, good morning, Your Honor. Joanna Manillo, also from Quinn Emanuel, on behalf of Mrs. Pete. Mrs. Hyrapetian, good morning, Your Honor. Mary Hyrapetian, also from Quinn Emanuel, on behalf of Miss Pete. Mr. O'Sullivan, and Miss Pete herself is here in the courtroom with us to my right. The court, thank you. Good morning, Miss Pete. And it's Miss Hyrapetian. Miss Hyrapetian, yes, Your Honor. The court, that's a mouthful. All right. I thought mine was bad. And then that's when she said, it's Miss Menino. All right. And for Miss Cooper, where is Miss Cooper? Miss Dixon. Rhonda Dixon is here. I wasn't aware that my client was supposed to be here. So, the court, can you pull up the order, Miss Dixon? Setting this case for pre-trial conference, ma'am. Miss Dixon, sure. Sorry, Your Honor. The court, the order was entered back on October the 7th, docket entry 150. Do you have it, Miss Dixon? Miss Dixon, yes, I do. And I note that it says parties and their counsel. The court, and it's in bold text as well. Miss Dixon, yes, Your Honor. I'm sorry. That was my mistake. I was going back and forth with other counsel to see if he could be here, and he's in a murder trial, so I must have missed it. I apologize because we didn't make any arrangements for her to travel. Can I send her a Zoom? The court, send her a Zoom link, please. We will wait for her. Yes. May I do that, Your Honor? Please do. We're waiting. Thank you. Pause in the proceedings, as y'all can see there. Mrs. Dixon, Your Honor, I have someone from my staff trying to reach her. I wasn't able to get her on the phone, but I texted her and sent her an email with the link. Then there was another pause in the proceedings, as y'all can see there. The court, Ms. Dixon, Ms. Dixon. Yes, Your Honor. I'm still trying to reach my client. The court, I see your client on Zoom. Is that not your client, Ms. Cooper? Ms. Dixon, let's see. Yes, that is her. Thank you. The court, all right. So we have Milagro Elizabeth Cooper on Zoom as well. Ms. Cooper, your presence was required here in my courtroom today. That was my court order that was entered in early October. Are you hearing us all right? Ms. Cooper, yes, ma'am. I can hear you now. The court, all right. This is a pretrial conference. This case is set to begin trial on November the 17th. We're going to be going over a number of important matters this morning, including the trial schedule, trial exhibits, witnesses, jury instructions. Why don't we begin? Then, with the schedule for the trial, I think the parties anticipated 4 days for the trial. Is that correct, Mr. O'Sullivan? Yes, Your Honor. The court, is that still Miss Dixon? Your Honor, I don't think that's reasonable with the amount of exhibits. They've given us 220 exhibits, so I don't see that being reasonable. The court, I didn't think it was a fair estimate. I thought you all would need additional time beyond the 4 days noted in the pre-trial stipulation. How many days for trial, in your estimation, Miss Dixon? Miss Dixon, at least 7, I think. The court, Mr. O'Sullivan, Mr. O'Sullivan. Well, the last time we discussed this with Miss Dixon, I think we said our case would be 3 days. And when we went through what would be left, assuming that Ms. Cooper testifies in our case, she didn't really have probably many witnesses. So I thought 1 day after that. So trials often take longer than expected, but our effort would be to make it as short as it could be to do justice to it, to get the case done. The court. So we're going to It says, so we're going to start trial on November the 17th, the second week of the trial period. Of course, it's a short week because it's Thanksgiving on Thursday and Friday is a holiday. So if we start on Monday the 17th, I'll be telling the jurors that we expect to be done by Wednesday the 26th, the latest. Is that a fair estimate from both sides? Mr. O'Sullivan. Yes, from the plaintiff. Ms. Dixon, I think so. The court, all right. We're going to be picking 6 jurors, 2 alternates. The 2 alternates do deliberate. It says we're probably try to pick more than 2 alternates, given the Thanksgiving holidays. I don't want to lose jurors. So my goal is to pick about 3 or 4 alternates who would, if they're still here at the end of the trial, also deliberate with the rest of the jurors. I allow the attorneys to conduct some limited voir dire after I've conducted the voir dire. Have the parties submitted proposed voir dire questions already or no? Mr. O'Sullivan, we've not done that yet, Your Honor. Ms. Dixon, no. The court, it would behoove you to submit proposed voir dire questions since you have limited time to ask questions of the venire members. I would ask as many from those that the party suggests as I deem appropriate. You'll all exercise your cause challenges before we entertain peremptories. There's no back striking, and I alternate back and forth in the selection of a juror, first asking the plaintiff and then asking the defendant first. Are there any questions regarding jury selection in the trial schedule? Mr. O'Sullivan. Typically, Judge, how long do the lawyers get to talk to the venire? The court, 15 minutes, 15 minutes each side. Ms. Dixon, Your Honor, I have another individual that would like to join who works for and as y'all can see there, that is her law firm, the Acilia. Okay, let's continue. She's not admitted to the court, but she's going to assist with the exhibits. The court, all right. And I am not going to butcher her name, but as y'all can see, that is her name. Nataja BNM. All right, so we're just going to say Miss Ben. All right, so Miss Ben, good morning, Judge. The court, good morning. Miss Dixon, so she submitted her request to be entered. She's licensed in Florida, and she submitted her request to be entered into the court. So she expects to be part of the case, but I don't believe it's been signed yet by the court. The court, I don't have any motion that Miss Ben has filed or that you have filed on her behalf. There's nothing on the docket. Ms. Dixon, I think it's not. Well, I'll file a motion, but I believe she's saying that she put in her application to be admitted to the federal court. She's admitted to Florida, but she's not admitted to this court. The court, all right, let's move on. Let's discuss, if we could, we're going to get to the jury instructions. That's going to be somewhat time consuming, given that you folks Have quite a bit of disagreement on those. Let's address the trial exhibits. I'll hear first from plaintiff objections to any of the defendant's proposed trial exhibits. Mr. O'Sullivan. Yes, Your Honor. Should I present from here? The court, you're probably more comfortable there, Mr. O'Sullivan. I would imagine. Mr. O'Sullivan, if I could just take a moment to kind of bring the court to where we are. The court, certainly, Mr. O'Sullivan. The package that we're presenting you today is not as far along as it often is at this stage of the case. And we have had a number of meet and confers in sessions and exhibit by exhibit discussions. At the end of all that, we still don't have sort of a complete both sides understood. Y'all can see, understand both sides' position on each exhibit and why they object or are willing to waive. We have, I think, the court. All right. So I'm sorry to interrupt you, but I like to have all of the exhibits pre-admitted so that we can save time and we don't waste jurors' time unnecessarily during the trial. So we're going to have to meet once more for the 17th to pre-admit whatever outstanding exhibits are out there that you have not identified yet. Mr. O'Sullivan. Yes, Your Honor. The court. So let's pick a date and time. And for this, Ms. Dixon, you and your client need to be here. Is that clear? Or do I need to communicate it in some other way? Ms. Dixon? No, no, Your Honor. I will be there. Thank you, Your Honor. Mr. O'Sullivan. Sorry to interrupt, Judge, but what I was going to say is knowing we have to do that. We do have a number of the court, yes. Mr. O'Sullivan, objections that the defense has made to our exhibits that I think will answer some of the 3 or 4 questions that are going to come up in all of them. So we are prepared to at least go through on the ones where we did get to an impasse, I guess, on admissibility or authentication. And we can just go through those pretty quickly, I think. My colleague is prepared to do that. The court, all right, let's set up the next date to go through whatever outstanding exhibits there are. How is Monday, November the 10th at 11 a.m.? Ms. Dixon, that's fine, Your Honor. Mr. O'Sullivan, good for the plaintiff. The court, all right, November the 10th at 11 a.m. All outstanding trial exhibits and any other unresolved matters that were unable to conclude today. So let's address those that you can, the exhibits that you object to that the defendant would like to present at trial. Mr. O'Sullivan. Okay, so I think from our side, we will, I think, start with the ones that they've objected to that we think the objections are unreasonable. And we're asking for is that the court, no, I wanted to first address your objections to theirs, defendant's proposed exhibits, and then I'll hear from Ms. Dixon on her objections to yours, Mr. O'Sullivan. Okay, I'm going to see the mic to Ms. Manillo. The court, all right, not a problem. Ms. Manillo. Certainly, Your Honor. At first, I'm happy to stand or go to the podium. The court, you're probably better off. It's a long day. Ms. Manillo, great, thank you, Your Honor. I'd like to start at Defense Exhibit 38. The court, where do I find these, Ms. Manillo? Ms. Manillo, we have, my colleague is going to be able to pull them up on the Zoom screen, if that works, Your Honor. The court, great, Ms. Manillo. And then that way, Ms. Dixon and her client can see as well. So as we're waiting for it to be pulled up, Your Honor, we have multiple objections to this. I think the first objection is that we believe that admitting this document into evidence would actually violate one of the parties' joint pretrial stipulations that resolve the potential motion in limine that we anticipated bringing. So once Your Honor sees the exhibit, I'm happy to talk about that in a little bit more detail. The court, all right, Ms. Manillo, Your Honor, if it would be helpful, I'm happy to pull up the joint pretrial stipulation and so Your Honor can see the language of the stipulation that is going to relate to this exhibit. The court, I have it here. What page? Miss Manillo, it is part section G of the pretrial stipulation. 1 moment, Your Honor. I'll give you the page. The court, I have it here. Concise statement of issues of law on which there is agreement. Miss Manillo, correct. It's paragraph 4 in that section. The court, all right. There is to be no improper character evidence unless you open the door. Miss Manillo, correct. And we framed it that way because it is highly publicized. It is a highly publicized trial. But there was a particular discussion that we had during meet and confers about evidence that the defendant spoke about with Miss Pete during her deposition. We brought it up to them. We all agreed it would be inadmissible. And the statements that are in defense exhibit 38 are the underlying statements that relate to the parties' discussion that we all agreed was inadmissible. So we believe that based on the prior agreement that obviated the need for us to file a motion in limine on this topic, this exhibit should be excluded. Obviously, there are other objections we have to that, but that is the primary one that we wanted to raise with Your Honor. The court, all right, I'll hear from Ms. Dixon. Ms. Dixon, yes, I think the issue here was we stated we wouldn't talk about any prior arrest, not prior acts. So we had asked the question, had she been arrested before in conjunction with this particular activity? She was arrested and there was a mugshot. So what we agreed was not to show the mugshot and the arrest because that would be that we thought would be unduly prejudicial and possibly harassing, well, I'm sorry, embarrassing to her. So we agreed to that. That doesn't mean we didn't agree to mention the incident. And it's also been out in the public. As you can see, this is a post that was publicly released. And it was also mentioned on Hollywood Unlocked. And a number of other media personalities and bloggers also, well, had also mentioned this, not just milagrogramz. It's not something that is a surprise. It's not something that the public doesn't already know about. And there's no reason not to mention it because it's already been out in the public. It's not going to, it's not going to make it. It's not going to, well, it's not going to republish it, actually, Ms. Manillo. Your Honor, if I may respond to those points. As Your Honor, I'm sure is well aware, the question of whether or not something was published and is public has no bearing on the question of matter. It is inadmissible character evidence, which is what the parties discussed. Of course. Oh, excuse me. 1 second. All right. Sorry about that. Under the federal rules of evidence, an arrest is inadmissible character evidence. It cannot be admitted into evidence, nor can the facts that relate to that arrest. It's not even clear that this is, in fact, I understand from Ms. Dix's argument just a moment ago that her belief and her client's belief is that this is about my client, but it's not clear from the text that it is, in fact, about my client, that the accusations in there. And in any event, Your Honor, whether or not it's public or has been published on Instagram, A, would not obviate the objection that we have as to improper character evidence. And we also, as I mentioned a moment ago, have other objections to this document coming into evidence. Principally, hearsay, of course, authenticity issues. We're not sure how defendant anticipates laying the appropriate foundation to get this into evidence. And then there's also the question of relevance. And I, at this moment in time, and based on Ms. Dix's proffer, I don't have an answer to that question. To those 3 questions in my mind, the court, did you all confer about this before today? Ms. Molino, we did. Ms. Dixon, no, not this particular thing. We mostly conferred about the plaintiff's exhibits and not so much ours. Ms. Manila, and Your Honor, if I could speak to that a little bit. We, as Mr. O'Sullivan mentioned, we were not as far along as we wanted to be. We did try to confer multiple times. We had 3, I believe 3 meet and confers over the last 2 days where we only spoke primarily about our exhibits. We received the defenses, a folder containing the defense exhibits for the first time, not yesterday, the day before, and we sent our objections to them right away. Because before that, we did our best based on the descriptions that they provided for their exhibits on their exhibit list to identify objections that we would have to them. But there was no way for us to identify the actual exhibits because there were bait stamps. The court, so I don't want to be having, we're going to be here more than today if every exhibit involves the length of the discussion, right? And it's apparent to me that you all have not conferred about this exhibit. So we're going to be meeting again on the day and at the time that I mentioned. Between now and then, have that conferral. Miss Manillo, yes, Your Honor. The court, go over all of your various objections to the exhibit with Miss Dixon and her counsel. Well, I'm sorry, co-counsel. And so when we meet again, we'll know whether it's resolved or not, and you will have narrowed down what the issues of disagreements are. Miss Manillo, certainly, Your Honor. And I would note that that would apply to our objections, generally speaking, to the defendant's exhibits because we have not had a chance to confer with them about that. The court, all right. So you're not prepared to go over defendant's exhibits to which you object. Is that right? Miss Manillo, we have identified them, but based on Your Honor's discussion, the court, you have not conferred. Miss Manillo, we cannot talk about it. The court, you have not conferred. Okay, that was another requirement for today's pretrial conference. I understand you were not able to do that. Ms. Dixon, you need to confer with plaintiff's counsel between now and Monday, November the 10th, in a good faith effort to reach agreement on on these exhibits that you have on your exhibit list to which the plaintiff objects. Is that clear? Ms. Dixon, yes, Your Honor. The court, very good. Ms. Dixon, and to be clear, we actually sent in, well, she said we actually sent it a month ago. I have the email. We haven't changed much in ours. So we never, it wasn't 2 days ago. It was actually sent, according to my email, it was sent around the time that you sent your order, Your Honor. The court, well, if that's the Ms. Dixon, but we've just been focusing because they have, y'all, I want y'all to read this particular part here because they have such in copious, or however you say that word, copious. I'm sure I'm saying that word right, copious amount. If you recall, they had 400 exhibits at first, and they've cut them down to about 220 now. So the reason why it's been so difficult, first, they had hired LTI, and they had hundreds of thousands of exhibits to go through, and that was just wildly for a firm of my size and Jeremy's size. We just couldn't do it. They hired 11 attorneys to actually go through and call all these things from her Instagram, in her Discord, in her various social media accounts. So we didn't have the resources to do that. So I've been going through them as much as I can, but it's been tough because I have a busy schedule. And I also have, now I want to make sure I had got the actual uh, description of this word, macular degeneration. So what that means is a degenerative condition affecting the central part of the retina, which is the eye, and resulting in distortion or loss of central vision. So that's what that means. I wanted to make sure I had got that down. Okay. So let's continue. So I can only look at the computer for so long. I always have to have blue blockers and things to protect my eyes in order to look at mostly media. That's what makes it difficult. It says their list is 220 exhibits. They're mostly media, so they're not something physical that I can print out and review. I actually have to sit there with the computer with the list and open up each link and go through it. And a lot of it is cumulative and repetitive. Like for instance, they'll take a piece of something that she did audio. Well, they talking about station head now. As y'all can see right there on station head, and it's the exact same one in the second time, but it has maybe one or two more words. and then the third one has maybe three. And we had this discussion yesterday that maybe you could just make it the one that has the largest amount and then just go to the section that you're looking for, because there's just no reason to have all these repetitive and redundant pieces of information that we have to go through. And I would wish that they would cull through that, so that 220 exhibits is a lot. We've only gotten to 60 so far. The court, November the 10th. I expect the parties to be prepared to address your exhibits to which the plaintiff objects. Am I clear? Ms. Dixon, yes, Your Honor. Mr. O'Sullivan, yes, Your Honor. The court, thank you. Let's address the plaintiff's exhibits to which you object, Mrs. Dixon. Okay, let's see. This is Mrs. Dixon. Your Honor, I'm sorry. I'm trying to. So it's a little unwildly for me because the objections are next to them. So I have to review that. So for the first one, we objected regarding relevance and 403. The court, I'm sorry, what? Ms. Dixon, this was a discussion between the court. Ms. Dixon, what exhibit are we talking about? Ms. Dixon, exhibit number one. Mr. O'Sullivan, Dan, can you pull that up? Ms. Dixon, yeah, we find that to be vague, ambiguous. The court, what is that? Ms. Dixon, it's not really anything. It's just saying Sunstar is on the phone. He doesn't speak to anything that has anything to do with the allegations in his complaint. The court, what is, who, excuse me, y'all, 1 second. All right, sorry about that. The court, what is the relevance of this exhibit to the plaintiff, Mr. O'Sullivan? That is actually from the defendant's phone. The court, oh, I see, Mr. O'Sullivan. This is the defendant in touch with this person, Noor King, their friend, literally talking about being in touch with Sunstar about the subjects that are in the complaint. I mean, part of the complaint is Sunstar, Daystar, and Milagro. Ms. Dixon, we can't find that. I mean, it just says Sunstar on the phone. It doesn't say what they're talking about. It doesn't show any relevance. Just Sunstar on the phone. And as y'all can see there, that is Noor's name. It's also a Blockster, and he's in the same situation as Milagro. He is not just a friend, he is a Blockster. And they're talking about something that they collaborated on blogging on or something like that. But it's not relevant to this case just because Sunstar is on the phone now. I mean, if they had something about what he was saying and it was relevant to the case, then I would say it would be, but it's just another case of just over aggressiveness with these exhibits. The court, Mr. O'Sullivan, I'll hear from you now. Mr. O'Sullivan, we're not submitting it as conclusive evidence or anything. It is some evidence that these people were in touch. That part of what was going on here was to violate the gag order in the criminal trial. They were working together and indirectly put out through Milagro, through Sunstar. And the fact that they're in touch is significant to our case. The court, objection overruled. The next objection. Ms. Dixon, Your Honor. The court, Ms. Dixon. Ms. Dixon, why is the gag order in the trial part of this trial? Ms. Dixon, I know. Ms. Dixon, oh, I'm sorry. The court, Ms. Dixon, I know. Ms. Dixon, this is defamation. The court, Ms. Dixon, I know we're on a Zoom platform, ma'am, but when I speak, you must stop speaking. Am I clear about that? Ms. Dixon, yes, Your Honor. The court, you were a prosecutor, right? Ms. Dixon, yes. No, I worked in the appellate division. Division. I wasn't a prosecutor. The court, correct. All right. So when I speak, a lawyer must stop speaking. Ms. Dixon, understood. The court, thank you. And I ruled. I overruled your objection. The next question. Ms. Dixon, that would be 2, Exhibit 2. The court, yes. Ms. Dixon, I'm sorry. I'm trying to pull it up. Pretty much the same objection. This is cumulative. I don't even know what it means. There's no foundation, no authentication, no relevance. This is just a picture of a person, Noor King, I believe. Is that Emil? I don't know. It's another blogger. And I think it's the guy they were just talking about. Mr. O'Sullivan, I don't think we can hear the audio. The court, what would I expect to hear? What's the relevance of what he says or what is said on this exhibit? Mr. Humphrey, Your Honor, if I could play it from my screen, I tested it. The court, yes, sure. Mr. Humphrey, Your Honor, if Ms. Dixon could just stop sharing, then I could share my screen. Ms. Dixon, one question for clarification, Your Honor. Wouldn't they be required to provide transcripts if they're going to show any audio? Ms. Manillo, Your Honor, I can answer that question. We anticipate and we identified on our exhibit list for any audio that we intended to emit at trial. We will have certified transcripts available. The court, all right. Mr. Humphrey, Your Honor, I can't share my screen because Ms. Dixon is sharing. Mr. O'Sullivan, Rhonda, can you hear anything? The court, you need to unshare your screen, ma'am, please. Ms. Dixon, unshare my screen. And then as y'all can see there, it says audio played. All right. So this is going to be part one. All right. Tune in for part two. Part one has ended. They finna get it to some tea, y'all. All right. Now, wait for part two. We'll get into this. We'll get into what's going on here, and we continue. All right. Now, as I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. Stay tuned for part two. Take care.